and welcome to AP on Play. Thanks for tuning in today. Today's guest is Scott Farida, attorney at law and candidate for Oakland County Prosecutor's Office. He's going to be on the ballot in the general election in November. Welcome, Scott.
Oh, thank you very much for having me, and it's great to be here on primary day.
It is primary day. Thanks so much for joining us. We have a lot to talk about, but let me first ask you to say a few words about yourself. Give the audience a flair for your background, where you grew up, what you've been doing with yourself.
Sure. Well, I have been an attorney since 2017, spent pretty much my entire career in the Oakland County Prosecutor's Office, predominantly an assistant prosecuting attorney, which is the type of attorney that litigates the cases normally coming through the office. In early 2022 or thereabouts, I became the acting chief of the Family Support Division as needed, held that role up until the time I left in June of 23. And I presented and worked with the Prosecuting Attorneys Association of Michigan, earning the Rising Star Award, to judges statewide with the Michigan Judicial Institute, Michigan Title 4D program, Michigan Institute for Continuing Legal Education. So I got a little bit of experience.
Yes, very good. So let me ask you then, how do you wake up one morning and decide you're going to challenge the incumbent and run for Oakland County Prosecutor? An easy question to get started.
It's an interesting question. I mean, I left in June of 23. I thought, I was making a mistake. I want to go back. I gave him 3 weeks notice, extended for a week being out. I knew I was not going back there. And about a month after that, I really just thought I've always wanted to serve my community, to make it better. I mean, things don't get better unless we actually take the effort to do it. And I was so frustrated by the policies and what had been going on. And I just thought, this is my community. I want all of us to have justice, real substantive justice. I want us to have a safe community and not be bound by essentially political extremism.
Well, as you may or may not know, I was a prosecutor for 15 years. I'm now a criminal defense attorney, so I'll try to hit it down the middle during this program, and we'll see where it takes us. But I do want to, my idea in inviting you was to, as I might have mentioned, we're a nonpartisan show, but my idea was to educate my audience on the policies of the Oakland County Prosecutor's Office, which affects everybody, whether you've ever been the victim of a crime or not. You have been affected by the Oakland County Prosecutor's Office. And I'd like to hear from you what policies are working and what aren't working, and how you think you can get in there and change it up.
Absolutely. And I know that you are going to be fair as a defense attorney. There's an old joke I heard, how criminal attorneys treat each other as civil and how civil attorneys treat each other as criminal. So, but to go to your question, how things have been handled and what the issue is, I mean, there has been such a fundamental shift away from public safety and victim advocacy. I mean, Karen McDonald's chief of litigation told every attorney in the office, we do not represent the victim. Quote, that's great at election time. Compare that to L. Brooks Patterson, who called himself the victim's lawyer. If you look at just in terms of the structure, I mean, the first person that came in to talk to attorneys office wide, spent some of his time talking about charging crime. And it was frankly undercharging. It was not bringing all the counts for what a person actually committed. It was just picking a lower count. And the example given twice was murder in the first degree.
Well, let's talk about charging, because in my experience as a criminal defense attorney, I think the government overcharges. So you're telling me that there was a directive when you were a line prosecutor to undercharge.
Well, I wasn't in the warrants division, to be clear. I didn't have that specific policy. I'm talking about what this attorney conveyed to us that we should be considering, we should be doing.
Okay.
What I'd say is, it's interesting because a lot of charges I've seen have been undercharged, at least in terms of the cases that have met the press. I mean, there were 2 cases in particular in which people killed individuals while they were driving and fleeing from police. Based on the facts of both those cases, and again, I'm going off what's in the press. I obviously don't have access to the prosecutor's file. Those seem to be some derivation of murder, maybe even felony murder, but they weren't. I mean, one of those, I believe, was a manslaughter charge after killing a 13-year-old, almost killing her 10-year-old sister, and almost killing the mother. I mean, there are many substantial cases that are pled, even ones that are concluded. I mean, there was one case where a man was convicted of murdering his own nephew 12 years ago. My understanding it was over money. Case is done, you think, at that point, but no. I mean, this was just in the last year or so where the current administration went and tried to retroactively plea him down to murder too. And this went all the way to the top. I mean, the chief assistant, as well as the head of the Conviction Integrity Unit, told the judge, a report's done. It goes to the prosecutor for her eyes only, and Karen McDowell was the one to make that decision. So, and by the way, on that case, and I said tried because facts were so egregious, the judge refused to enter the agreement, even though it was a joint motion. So there is a huge issue going on in terms of how crime is handled. But
let's talk about undercharging for a moment, since that's what we led with. Is the idea that undercharging will lead to a guilty plea?
I can't say it for certain because of the rhetoric that was used. I think that part of it is probably because of the specter of mass incarceration, which the administration has, to me, been kind of vague in what they feel is an issue there. And obviously, if you have, as you know, as a prosecutor and defense attorney, if you have lower charges, then the maximum is lower, but also the guideline range is lower.
Right.
So it's easier to get away with, oh yeah, we're going to just, have a lighter sentence, have probation.
And Scott, explain to our audience what's a stat max and what's a guideline, because we're speaking the same language, but they need to understand us.
So when a person is charged with a crime, and I'm going to talk felonies here, right? Because when a person is charged with a felony, they're convicted, whether it's a plea or whether it's by a jury, then you have the maximum sentence allowable by law. Now, most charges, you can never actually use the full sentence. There's this something called, you and I called the 2/3 rule, which without getting into that, that's its own limit. But there's also something called the sentencing guidelines. Essentially, there's a whole list of factors and there's a range. For instance, I'm just pulling this out of the hat. It could be 2 months to 21 months, and a judge is ordinarily supposed to sentence in there.
Right, and let me just jump in to explain. These sentencing guidelines are based on a number of factors, including the severity of the crime, the criminal history of the defendant,
number of victims, the type of harm, whether the person needed medical treatment in cases, psychological treatment, whether a weapon was used, a whole host of things.
So those factors are really reduced to a mathematic formula and result in a guideline range that the court tends to hit the guideline range. And beyond the guideline range, there's what we said is the statutory max. So for example, the stat max for, let's say, I think maybe voluntary manslaughter might be 20 years, but the guidelines might be 10 to 12. So the idea is that the court would sentence the defendant to the guidelines, but can go up to the stat max.
And it's important to hit, too, at this point, actually, the policy for repeat felons, because it's directly germane. So every prior administration, Democrat or Republican, you would file what's called the habitual notice. For the audience, if a person has a prior felony record, the prosecutor has to file a notice of those felonies, and that increases both the overall sentence and the guideline range. The reason it was always filed is, as you know, you can withdraw it if you don't want to proceed. However, if you don't get that filed, within the time frame, whether it's the arraignment or the pretrial, depending on if it's an arraignment by mail, it's lost forever. So you get some really egregious facts that come out on the case. You don't get to go before the judge and say, oh, we goofed, Your Honor. Will you please just let us? I mean, it's lost. We got an email very early on under the current administration that was no longer the policy, that we should have that be automatic, something along the lines of we need to think critically about what's necessary, et cetera, et cetera. But the problem is, when you do that, you're giving that individual a break up front. And I say that because a lot of times, depending on the division and the attorneys and the workload, the person reviewing the HAB notice isn't necessarily the one who knows about the case. You'd hope they would have talked to the victim already, but if they don't, they have a very limited set of facts. And it's better, at least from my perspective, to have that available as a tool, particularly when you know that there are victims who suffered serious harm, than to right from the outset say, nah, we're not going to do that.
Okay, let me say what you just said and make sure I got it right.
Yeah.
You said HAP notice. You're saying the habitual offender notice.
Yep.
So what you're saying is, if a person is a habitual offender,
yes,
that notice that they're a habitual offender needs to be filed from the get-go.
Exactly.
Putting the defendant, the defense attorney, putting all parties on notice that, hey, you're a habitual offender, hence your guidelines might be higher than you think.
Far more eloquent than I. You got...
And if that notice is not filed from the get-go, the prosecution loses forever its right to file that.
Exactly.
And that makes sense to me because the issue is notice. So if if the government hasn't put you on notice from the get-go, it makes sense to me they can't.
Exactly. And that to me is the issue because, look, I want to be clear, though, and I'm sure we'll talk more about policy. I'm not suggesting we need some wild swing to the opposite political spectrum. That I don't believe that political extremism in either direction works when it comes to prosecution. But my goal is fairness and proportionality. Again, if you do not have the tools available, especially when a person's a repeat felon, this isn't their first rodeo.
Right.
Having it available in case that's needed is reasonable. It's the proper course of action. Again, it's every prior prosecutor from a bipartisan standpoint had that. And that's not to say every person needs to, at the end of the day, you pursue it and you get the max sentence. But what it means is you don't abandon a tool that can be used to get justice for a victim up front. That you make a decision when you have all the facts, when you've looked through the file, when hearings have occurred, and you have what's necessary to make a proper determination. That's my perspective.
Because the government can always withdraw that notice.
Even up to the time of sentencing, you could pursue it all the way up there and you could tell the judge in the sentencing, Your Honor, the people are no longer pursuing the sentencing enhancement and we'd ask that be dismissed, and it's gone. It's like it didn't even exist. Again, that's any time throughout the case.
But you're saying you received a directive to not file the habitual notice as a matter of course.
Exactly. That should no longer be automatic, I believe how it was phrased, and it went on from there. And here's the issue as well, too. It's not just about the facts of the case, it's conduct. I mean, I've had cases where the victims are contacted by the defendant or their family. I mean, when you have things going on throughout a case that demonstrate that a person does not care about the rights of the victim, does not care about the law, is willing to act as improperly as necessary to help themselves. Again, all that stuff is an indication. It's why, to me, is far better to have that going through the case and make that determination at the appropriate time. And I do, and to be clear as well, because I do think it's the matter of course. There certainly are going to be some cases where you have something so attenuated, so out there, so old that it's just not practical.
Sure.
But the rule should be to file that notice for the enhancement as opposed to, well, we need to look at, et cetera.
What you say enhancement, and that my mind goes to narcotics cases.
Mm-hmm.
Do you have an experience with, tell me about the narcotics unit, how it's run at the prosecutor's office, what they're doing right, what you think you could come up and change?
Well, the narcotics division, unit, used to be called the narcotics unit and is now the trafficking unit. I'm not sure exactly all the operations because internally and externally, it's been a bit unclear as to what their focus is. And I'm not knocking the people in that team. I know them, including the leader. I mean, they're very good attorneys, but it's top down, right? It's how the policy is going to have. I do think in relation to drugs, what we really need to substantively do is deal with addiction. And I say that because, one of the most frustrating things, not to get too political, I know it's nonpartisan, but, I've seen Karen McDonald talk about the drug court and the importance. And recently, I believe, announced that she appointed an attorney as head of alternate disposition.
Actually, I'm glad you mentioned drug court. Tell our audience, what is drug court?
To give the most general, breakdown as opposed to the specific nuances of how it functions differently. Essentially, it is not what you would call a normal case, normal probation. The idea is that frankly, the best way to describe it is almost like a Narcotics Anonymous meeting. You have people together. There's one judge. I believe it's monthly meetings. They still do testing. You get sort of, I won't call it rewards, but, maybe a pin or you get something. The idea is much more focused on dealing with the drug addiction as opposed to what you would normally see in probation, which is just what you call general rehabilitation, right? The idea behind the drug court is the underlying issue is the drug addiction. And if you don't deal with that, you're not going to be able to deal with the other factors that you normally want to have that outcome.
And am I eligible for drug court if I'm charged with trafficking narcotics, or am I only eligible if I'm charged with
Well, typically it's an individual with an addiction. Trafficking is not something like use or possession. I would have to go through the specific statutes to name each and every one that you were eligible for. But beyond the fact that you need to actually have that charge that's related to your use and you need to actually be a drug addict, to my understanding is there's also a panel process for approvals. It's kind of like the Combat Veterans Court, where it's a group that makes a decision because there's limited spaces. Which again is why I have an issue with, how it's presented. You hear the talk like it matters, but in my experience in the office, all this stuff that Karen does like that is image over substance. When I was there, we had a minimum of 3 progressive prosecution presentations. Attorneys were somewhere between encouraged or forced to attend. We had probably 2 or 3 DEI ones on the low end. And the reason I raise this is we never had a focus on drug addiction. And whether it be the drug court specifically or otherwise. And if you look at the numbers, the deaths in the state of Michigan from drug overdoses are near double the amount of people who are killed by firearms, and all types of killing from firearms, including the 50 to 60% that are suicides. We have an enormous amount of our community that's not just suffering from narcotics abuse and addiction, but dying from it.
So let's talk about what your ideas. I agree with you on the addiction. And too many people, in my opinion, who get pinched by the criminal justice system should be more appropriately dealt with in rehab or addiction services. So what would you do to maybe overhaul drug treatment court, or what would you do to emphasize addiction therapy over criminal prosecution?
Well, the goal that I would have is the entire structure, and I want to start a program that's small. I don't want to have overexpansive and then you don't get good numbers. Probably it would be people who either don't have a felony record or their prior felonies are drug ones, right? And we're talking people who are charged with actual possession, not incidental, right? A person stabs someone and there's cocaine in their pocket. The overwhelming charge there is not, the possession, right?
This is an important distinction.
Yes. So, the goal to me would be, whether it be the structure of how we do the plea for reduction or the sentencing itself, have it be entirely based on treatment. Have the outcome, whether it be the reduction or to a charge or whether it be the actual sentencing, be entirely focused on the person's successful completion of drug treatment. Don't just leave it up to the judge. Don't just say, well, the judge or probation will figure out. No, figure out from the outset. Talk with the attorney and figure out, does this person have family supporting them? Is this something that needs to be inpatient or outpatient? Because frankly, some people aren't going to seed in outpatient treatment. Get information from the attorney, obviously, if they're willing to provide it, they want to engage with this, about prior treatment attempts, right? What's been done? Don't just keep repeating the steps that have failed over and over. You don't need the drug court. The prosecutor has an enormous amount of power and if the drug court is full because there's limited capacity, you can absolutely work with attorneys, create a larger program, try partnering up with whether they be nonprofits or the like who deal with drug addiction, have a clear path forward for people and have that goal be breaking the cycle of addiction. I
would like to see more funding available for inpatient addiction therapy.
Absolutely. Then I didn't address that as much because the prosecutor doesn't have the power for that. The prosecutor can come out saying like, hey, you board of commissioners or state of Michigan, you need to fund this more. And, that can be powerful. But to me, we don't even need to wait for that. The prosecutor can absolutely start dealing with this if that's a priority. But you are 100% right. I mean, to me, it's not as, I don't want to use the term glamorous, but some issues really tug at the heartstrings. There's some things like when you see a shooting, there's a lot more press. You don't see let's say, news report about a person who OD'd in Oakland County, in an abandoned building. Right. You don't have that exposure. A lot of politicians who have this whole thing where it's words, not actual action, to them, it's not something that's going to get them press. It's not something that matters. And it's very disturbing to see that type of behavior.
Tell me what else you'd like to see if you were elected. Tell me what other overhauls you would make, or maybe there's some policies in place that you do agree with.
That's a very loaded question. We could, if we're talking about policies to change, whether it's we could go through how public safety and victims are handled. We can talk about management. We could talk about the alleged misappropriation of funds.
Let's talk about public safety.
Let's start. Okay.
Yeah, let's start with public safety. And actually, I bring it up because of this transnational gang that everybody in Oakland County is reading about and hyper-vigilant about. So, let's talk about public safety.
And we've seen, too, Mike Bouchard, the sheriff has done a tremendous job with investigations and has really kept people updated. I don't know about you. I appreciate that, especially his candor, too. Like, these are the groups. This is where we're seeing them come from. This is the net. This is giving people a clear idea as to the scale of the problem. But
I think he did wasn't there a town hall not long ago?
He did a town hall, and he's done a number of press conferences too.
Yes.
And very transparent. To me, we need to address things on, if you want to call it, the two big ends of the spectrum. A lot of people I talk to, particularly if they have strong political feelings, you have one of two camps for them. Number one, they feel, they act as though criminals are, for lack of a better term, subhuman and need to be crushed. Or do you have the alternative where it's every criminal is a poor, tragic victim of society that wants to do better? No. You and I both know, working in the practice of law, there are some people who are in a rough position who don't like where they're in, and you need to be able to set them on a path so it doesn't get worse. And you have some people that just don't care. You'll see them come back and back on violations of probation where they've made zero effort. It's a nothingness thing. So in public safety, we absolutely need to address the most egregious offenses proportionally. Stop these extreme pleas for child killers, murderers, sex offenders. When the facts are terrible, look, I know you might not like this as a defense attorney because it means more trials. But to me, this is what happens.
Let me just say, I like justice. When I was a prosecutor, I liked justice, and as a defense attorney, I like justice.
Okay.
And I can argue both ends of a case because cases are complex, and it's never so easy as somebody did a bad thing. It's always, let's look at the context as to why somebody did a bad thing. Some people can be rehabilitated, and in my opinion, some people can't. So I take a very holistic approach to the criminal justice system.
And that's the thing is, look, on those really extreme cases, if an attorney is like, oh, my client will only accept this and it's a really low position, the response is, okay, we're going to trial. Not, oh, my hands are tied, I guess we got to give you this. That's been one huge issue that's gone on. It means proportionality, to look at the harm cost to victims, not keep constantly having the focus on what could be done for defendants. But again, looking now at the other end of the spectrum, look at the type of harm and looking can be done. A good example, let me just use a common crime, which is retail fraud. Mm-hmm. Person either has all theft-based charges or, that might be their first offense, never completed high school, never held down a job, right? Okay. Have a plea structure, whether it is for the offense itself or for the sentencing, that focuses on that requires them to go to various organizations to get help. I'm not sure.
Obtain a GED is a good starting point.
That is exactly. Mm-hmm. Have it be that you're required to maintain employment. Help get people in touch with the groups that do job placement and help with state benefits. There are organizations that if a person qualifies for state benefits, they will help them apply. When you do that, you get the person out of the circumstances. When you do what to me is a politically extreme view, which is, I'll just plea him down, it was a nonviolent crime, they're in the exact same circumstances they were when they committed the crime. If you don't do anything to change those circumstances, you as the prosecutor are creating the revolving door. And that also lets you filter the type of people, because if you have a person who's made a genuine effort, who's gone and done these things, and even if everything isn't perfect, you see an improvement, you know that you can have that rehabilitative effect without, jail or prison. When a person doesn't do that, when they have all the options given to them, what's the expression? You can lead a horse to water, right?
Right.
If a person clearly demonstrates, no, they don't care, then you can take the proper course of action there. There's an attorney who I respected, Mark Berkman. He's retired now, but he told me before, and it's very true, when he described delayed sentences, he said, look, there's some people who are going to fake it for a month, for 2 months. You don't get to a year faking it, right? You don't have a person who does everything they need to for a substantial amount of time, and the second they're gone, it's just, back to my old ways,
Let me stop you. Have you explain what a delayed sentence is for our audience? Because this this affects a lot of people.
Yeah, delayed sentence is essentially what it sounds like. A sentencing can be delayed in Michigan up to a year. There's case law about how if it's at the defendant's request, it can potentially be more than a year as well. And essentially, it could be for multiple things. It could be because at the end of the road, you're going to reduce charges. That's something that I did a lot of in my role, and that's something that I really, truly believe in. It's what I truly think is going to help with some of these issues too, and allow us to have more flexibility when it comes to drug addiction, when it comes to mental health treatment, and all sorts of other things. But anyway, you can do that, or just at the end of the road. Let's say, you're on the fence. This person clearly committed this crime. Justice demands that this person have this on the record. But does it need to be jail? Can a person have probation be successful? You go through the delayed process. You have a number of requirements you agree to. The judge imposes their requirements. And at the end of the road, if they've done everything they need to, they're entitled to whatever that agreement was. Whatever you as the prosecution said, okay, let's do it. So,
and I believe that it is not a conviction. The delayed sentence, hang on, let me finish.
Sorry.
The delay, if the defendant avails themselves of the delayed sentence disposition, then the judge essentially holds the case in abeyance and imposes probation, maybe addiction therapy, whatever the issues are. And if the defendant has successfully completed this, then the case is closed without a conviction. And I've done this twice in the last summer, so that's why I'm mentioning it.
You can do that. The reason I say is it's what the agreement is. The prosecutor can, at the end of the road, dismiss, reduce, or have a sentencing agreement. It's all up to what you end up having.
So that's an important distinction.
Yeah, and technically speaking, at the delayed, how I did it is you're pleading guilty up front to whatever the charge is. If there's going to be a reduction, then what happens is party makes a motion to set aside the plea, and then the judge, you either, again, have it dismissed or plead to a reduced charge. And when you do that as well, too, if the person, this is the nice part about a delayed sentence, if a person demonstrates they don't care, you don't have to wait the full time. I mean, I would file motions to accelerate a delayed sentence, and this is the nice part, too, as well, to have the rehabilitative effect and give people a chance. If I saw someone who is messing up early on, I would file that motion and get us back before the judge.
Right.
And I wouldn't necessarily ask the judge, though, to terminate. I would say, look, I leave it to your discretion, Your Honor, but this needs to be clear that this is not a joke, this is not a game. And a lot of times that was like the warning shot across the bow that woke people up, especially during the pandemic when you're peering at home, sometimes in your pajamas, and it doesn't feel as real, right? Then people realize, okay, people are looking what I'm doing, people are watching, it's sink or swim time.
Yeah, and I think the point is to give first-time offenders and maybe low-level offenders a chance to get out from under.
Oh yeah,
so we should make clear that the delayed sentencing isn't for. You're not going to get a delayed sentencing if you've been charged with a violent crime. These are mostly for misdemeanors, domestic violence. I've used that before.
Well, it can technically be anything. It's policy, but from my perspective as prosecutor, I can tell you right now, you're not going to commit a terrible violent crime, and we're going, you know what? Let's see. I mean, sure, you stabbed the person 3 times because you were upset about your order at the McDonald's,
right?
But no, that's the thing. You're 100% right. It is a tool. And you need to have a prosecutor and an administration that's able to properly use it. Because if you're overbroad or you underutilize it, it's just wasted.
Yeah.
This comes to, again, the big issue in the office is overall there's a huge problem with management, and that's something I'm going to fix. I'll tell you that.
Well, Scott, we're almost out of time, although I think I could talk to you all day because, we speak the same language. Mm-hmm. What should we end on? If you were giving a closing argument as to why somebody should vote for change in November in the Oakland County Prosecutor's Office, what would you say?
I would say for every person, regardless of your politics, regardless of who you're looking on the federal level. If you want to focus on public safety and fairness in Oakland County, I'm the person for that role. I do not believe in political extremism. I want to depoliticize prosecution, partner up with both law enforcement and community groups, stop this adversarial approach that my opponent's taken, and really focus us back to what's worked from every prior administration, whether they were Republican or Democrat. Prosecution should never be political. We as a people, as a community, should always be focused on justice, true justice.
We are so grateful that you joined us today, and hope you come back in a few months' time and tell us how everything went and what you're doing with yourself.
Sounds fantastic. Thank you very much.
Thank you. Thank you so much, audience, for tuning into APN Play. See you next time.